All right, welcome, folks, to our new section for the media copyright and licensing class. Um, this week, we're going to be dealing with the mechanical license. You'll remember that we're looking at licensing from the most lucrative forms down, and so we started with the performance license of public performance, and now we're looking at the mechanical license. And so, let me get this over just a little bit. There you go. So the way I want to address this, I want to end with actually looking at a mechanical license, at least the outline of how to set one up. But to give the necessary context for that, it would be good to once again understand why we have a mechanical license, what they're designed to do. And give a little bit of historical background of how they came to be, and then the more recent development, who the typical licensors and licensees would be. This you'll remember from the music pipeline, which has that chart of all the folks that grant licenses, the license types, and then who needs to be licensed in order to conduct business. And then look at different types of mechanical license. So there's mechanical versus voluntary, and now we've got for the first time, a blanket mechanical license that just has gone into availability here in January, and that would be as opposed to a direct license. And we want to get an idea of how much mechanical licenses typically cost. So this is if it's compulsory, there's a maximum that's set by the government, and that's a statutory or by law. So it's a rate that is set in place by the government. It's a statutory rate with a T. And then the recent law I just talked about, 2018 Music Modernization Act, impacts our current operating environment for services like Spotify, for example. It kind of simplifies their life too, as well as non-interactive webcasts or streaming radio, to give the ability for them to operate kind of like on the model of the PROs, where you've got a blanket license that covers millions of songs or a large group of songs, as opposed to individually negotiating. So it's a streamlining kind of a process there. And then, as I mentioned, we'll look at the mechanical license itself, how it's kind of set up, and I'll show you how it can be drafted in favor of the owner, which would be the licensor, or in favor of the user, who would be the licensee. Okay, so what's the deal, right? So basically, it's the license required. It's for licensing music in sound recordings. So it's one very easy way to look at it. If you've got a recording, there must be some underlying music there, right? And that's circle C. So the underlying composition is can be in what's the right word I'm looking for? So inscribed or fixed. That's the right word. So the underlying composition can be fixed in a lot of different ways. For a print music license, it's fixed usually, on a sheet of paper in terms of manuscript or the musical notation. But in the case of ever since Edison, 1870s, now we have the ability to actually fix a sound recording, right? So it's a phonorecord. So it's a record of a sound event. And so there is the need for a machine for that recording to then perform again, to become audible for us. And so the need for that machine and that equation is where mechanical comes from. And so, in short, the mechanical license allows a user, right, to turn the song as a composition, which would just be, the lyrics and the melody, and this is how it goes, into an actual recording. So it turns Circle C into Circle P. Um, Thanks to our presenters, we had some good information on the Harry Fox agency who's acting in the mechanical world, right? So now you've got all of your users are typically record labels or independent producers, people who want to make recordings, but they need access to the songs, right? They need to have access to the songs and permission from the song owners in order to create these recordings. Um, so imagine all of the owners once again, just like we saw with the PROs. You've got 1.5 million registered members between CSAC and ASCAP and BMI, if I recall correctly. So you've got over 1 million people on one side, or members, songwriters. And then you've got thousands of radio stations and other, performance outlets. And so trying to connect all of those dots, of course, would be a real pain in the rear end for any of those people to do individually. And so this is a clearinghouse, right? So the PROs are working in this way. So it's a one-stop shopping for people who want to come in and get these kinds of licenses. Now you've got Harry Fox that's doing the exact same thing on the mechanical side. And so independent producers and studio owners that are making demos all the way up to record labels, from the, personal label to an independent up to a major label. They all, need to make recordings, and to make recordings, they need to have permission to record the underlying composition. And so that's the name of the game here. So you've got 1.5 million songwriters, and then however many record labels there are of all different kinds, and independent producers, anyone who wants to make a record, can now go to Harry Fox and be like, okay, I want to record this song, and then they will provide you with a mechanical license. Basically, that's the idea. And so all of this came about, it goes back to like the first machines that were able to capture a song technically were music boxes, but it was really Edison's cylinder, in the 1870s, where it wasn't just the song and the composition, but it was a specific performance of that was captured, it was fixed in that cylinder. And that's really a remarkable thing when you think about the history of humanity, to be able to capture a sound event, the sound of someone's voice, before Edison. After a parent or grandparent passes away, the sound of their voice just becomes this fading kind of distant memory. And thanks to this, it's like a photograph for sound, right? Now you've got the ability to have that voice with you as time goes by. And so it's really a remarkable feat of engineering when you think about it. So that was 1870s. Now you kind of fast forward it a little bit. The piano roll, I guess, would be the next form of inscription, which is very similar to a music box. But they were super popular in the early 1900s. You just kind of plug it into your piano player, your player piano, and you wind the thing up, and it plays, and the keys on the piano plays as well. You see them a lot in old Western movies. It's kind of like the ghost playing piano, just goes by itself. Well, Aeolian was a piano roll manufacturer and player piano manufacturer, and they were so big that they kind of had a monopoly on that marketplace. And so that meant that they had exclusive agreements with the publishers, meaning that no other piano roll maker, it would be like a record company, right? That's the predecessor to the record companies, this piano roll company, um, they would be other companies were unable to get off of the ground because Aeolian had all these the great songs sort of locked up. And so in the 1909 copyright law, there is a this new idea of a compulsory mechanical license, which means that um, it breaks the exclusivity of those agreements, and it says that anyone can record any song without permission, as long as you're willing to pay the maximum rate that the government set. So the government set the ceiling on how much that would cost per song per copy of that song, which was initially like 2 cents. And what that did was that broke up Aeolian's stronghold on all of the music publishers, those exclusive deals. And so any music publisher, or I'm sorry, piano roll company could now come along and say, I'm going to record, I'm going to make a piano roll of this famous song, and it'll just be, my arrangement and my version of it. But I can do that without permission as long as I pay my 2 cents per copy per song. And so that 1909 law is interesting because it has this trust busting, right? It's breaking up a monopoly, which was referred to as a trust back then and sometimes still is. And you also start to find the, as a side note here, the fact that these songs, the mechanical license only protected non-dramatic works. And this language is also present in the Performing Rights Organization. So ASCAP and BMI do not protect and do not pretend to protect, Broadway musical shows. And so that's because dramatic works are licensed under a big umbrella called grand rights that we'll study later in the semester. But I just want to make sure that you realize that works that are part of a larger narrative, right? So these would be dramatic works. You've got the script and the set design and the costumes, and all of these copyrightable elements are part of a larger rights package. And so that's called dramatic licensing or grand rights. And so that exists outside of all this. So when you see non-dramatic in there, that's what that refers to. Okay, so looking back at what mechanical rights cover, there's a certain list of impacted media. We talked about music boxes and piano rolls on the front end of the technology. And then, of course, you've got Edison's cylinder, which then becomes a 78 RPM record, which then becomes a 33 and a 45 RPM record. Then you've got magnetic tape from the Second World War, and that comes into popularity in the 60s primarily with the 8-track tape, and then the 70s and the 80s are kind of a high point of cassette tapes, which are, I think, 1/4 of an inch tape. And then you've got the compact disc, the computer chip, hard drive storage devices, and finally we get down to iPhones, MP3 players, and the like, or anything that is able to convert a wireless binary code into music fits the bill, right? These are all machines that are doing that basic translation of a composition that's encoded, right? If without these machines, you can't appreciate, you can't play the music. Converts that code into a performance, right? So that's what the mechanical license does. Once again, now for any music user, right? So imagine you're an independent producer and you want to record a song, of a famous artist that you really like, but you aren't into tracking down the copyright owner and calling up the publisher and negotiating, the mechanical license. You just want to record the thing and pay the rate, and get out. There's this notice of intention, which is a letter that you need to write to indicate that you're doing this, and then you have to account to them every month at the maximum rate. So at the bottom of this page here, you can see the statutory rates they started at about 2 cents per. Now they're up to 9.1 cents. They really didn't move from the 2 cents all the way up to the 1970s. They remained 2 cents, and then they started to grow a lot with the music business. And then in 2006, they plateaued at 9.1 cents for any song that's under 5 minutes. And if you have a song that's over 5 minutes, then you pay 1.75 cents per minute for each, for however long in minutes that song is. And so, to record to do a cover song, basically, to make a recording of a cover song, you have to be prepared to pay that amount on a monthly basis. And you have to know who the owner is, and you write them this notice of intention that gives your contact info, what the title of the work is, who you believe the copyright owners to be, the type of recording that you're going to make. In other words, is this for distribution on what kind of a format, right? Is it going to have any physical format, like you're going to make a vinyl copy of it or a CD, or is it going to be for digital streaming only? And then when is your date of distribution, and who's involved, right? Is there who's the artist, who's the label, is there a catalog number? And so that's just that's called due diligence in the music business when it comes to mechanical licensing. So that's the work that you have to do instead of the alternative route is to contact the publisher. And usually they will work out a deal with you that is that is less than the statutory rate, that is cheaper than 9.1 cents per second, maybe a 3/4 rate, which I think comes out to about 6.75 or so cents. And so there is financial incentive to do that. Unfortunately, the music business being what it is, typically people just want to do the fun part, which is to make the record, and then let the chips fall where they may. But if you don't do this accounting, then you are technically in, send the notice of intention, and pay up on a monthly basis, then you are technically a copyright infringer. And so we studied a little bit about that and know what's involved there. Now, the most recent law of significance that impacts this area, which is, of course, mechanical licensing, is the Music Modernization Act of 2018. Now, it's important to recognize that 10 years before this, this law didn't come from just anywhere, right? And there are parts of the law that don't pertain to streaming, but it is important to see that part of the context leading up to 2018 that's important is a 2008 ruling that on-demand streams like Spotify, or what would become Spotify, were entitled to both performance royalties and mechanical royalties because they're playing on a public medium, being the internet, right? So that's a form of broadcast. But you also require a machine to perceive that recording. And so the mechanical royalty and the public performance royalty were both ruled as being, enacted or engaged. Those rights were engaged by the users, like Spotify. And so what the Music Modernization Act did for mechanical licensing in particular was to really simplify the equation. In particular for digital streaming services. And so especially for that use, they established the MLC, which is a music licensing collective. And the collective would work as a kind of subsidiary PRO for digital streamers, meaning that they would issue blanket licenses for digital delivery of musical works. They would address royalty disputes, and they also would oversee a database, a large database that would tether the Circle C owners to the Circle P owners, and so greatly simplifying what had been a directly negotiated situation. So Spotify would have to negotiate with the major labels, right, for their entire catalog, and so all of the different record labels would be in the mix, which is of course much more complicated than one blanket license that gives access to all of these recordings. So now on the Circle P side, when you look at from a copyright perspective, you've got the digital performance right and sound recordings. So Circle P has a digital performance right, which is administered by Sound Exchange. And now they also have this mechanical arm that's working on their behalf to simplify their lives and enable the distribution on a wide scale in this new format that includes that performance right and simplifies their ability to account to the copyright owners themselves. And like I said, this blanket license is available as an option, so they can go direct license or blanket license as of a couple months ago in January. So that's exciting. Very timely. All right, now a little bit of information about a mechanical license. So they're not necessarily, they don't need to be very complicated, usually between 1 and say 4 pages. Average length of ones that I've had to deal with have been about 2. And so there's going to be like a header that has all this basic information about like what's the song, what's the date, who are the writers, who are the publishers that are represented, what's the record company, the artist and the release information, and then what is the agreed upon royalty rate. So that's all in the header. So you've got the property, the owner and the user, and then finally how much. So that's all sort of in a block. And then in the body, you have a little bit more detailed language about, say, accounting frequency. And so accounting frequency is how often are you supposed to pay, right? So we talked about how if you went the compulsory mechanical license route, you would have to pay every single month, which is very frequently and pretty inconvenient compared to quarterly, right? Once every 3 months, or biannually, every 6 months, or annually, right? Which would be every 12 months. Music business standard is typically 4 to 6 months, by the way. So those middle two, depending on whether you're dealing with a huge company, they may just go every 6 months, or some of these performing rights organizations, as we saw, counted every 4 months. And then the body of the license will also indicate certain kinds of limitations. For example, how many recordings can be made of this song. So you may do a couple, or can not be made but be released. So one recording of said composition, when you get the best take, that's what you're going to release. The recordings can only be made in the United States or U.S. territories, for example. Those are common limitations. Once again, when you limit a license, you make it more valuable, because to get another recording or territories, if you want to record outside of the U.S., then that's going to necessitate another license, which is usually more money. And then it indicates what do you do if the person fails to account at the agreed upon, if it's quarterly, for example. Say the first 4 months go by, you're waiting for the accounting statement and the check, and they never come. So typically, mechanical licenses will give a 30-day grace period, and if there's no payment by the end of that time period, and you're into your 5th month, then the license is null and void, and so any further distribution, once again, is copyright infringement, right? So it's illegal. Now, there are ways, of course, that licenses, which are a form of contract, right? So any contract and license being a form of a contract can be structured in favor of one party or the other. And so the licensor, once again, is going to be the owner, usually represented by a music publisher, and the licensee is going to be the user. In this case, the most common user of a mechanical license would be a record company. And so if the owner wants to be favored here, they are going to require frequent accounting, right? So they want the money to be coming in regular, and so they can see if there are any problems. For example, are they dealing with, a responsible sort of partner in this deal? And they also want the rate to be the highest, and so that license will read for statutory rate. So, 1.9 cents. 1.9 cents, or the 1.75 being the max rate. In favor of the licensee, on the other hand, you've got this controlled composition clause, which some of the student presentations discuss, but basically the idea there is that the record company is looking at a situation where they're paying the recording artist the artist royalty in their contract, right, to do the performance and be on the recording. But in the situation where the artist is doing an original song, right, this is referred to. So the artist is in control of that composition from the licensing standpoint. The label's attitude is, look, we're already paying you, right, the artist royalty as in the contract, and now you're asking. Now we're in a position to paying you again for the mechanical license as the songwriter. And of course, labels don't, if they've got leverage, which they do, right? We don't have to record and or release and or market, right? So the label's got leverage at all of these points. We don't have to mess with your song, so you really should work with us on this. That's the unstated sort of pressure there. And so the controlled composition clause says, it builds in that 3/4 rate. So instead of the 9.1, it's an automatic 6 point, it's not 6.75, but it's, 6 and, a little bit more of a penny, 6 cents per copy, per song. And so that's built in. And so, of course, that's going to favor them. And they'll want to account far less frequently because it's a hassle, right? So you put that out to every 6 to 12 months. And so that's kind of, those are the high points of mechanical licenses I wanted to share with you. Just to look over the vocab at the end here, the compulsory mechanical license is the one that you can do if you are have a studio and you don't want to get permission from the songwriter. You can go this route. If you do want to get permission from the songwriter, you typically can negotiate a better rate. And so as a result, that's called a negotiated mechanical license. As of this past January, there is now a blanket mechanical license available to interactive and non-interactive streaming services. But those who prefer to, those rates are complex based on a lot of different factors. So we're not going to get into the rates of those blanket licenses, just like the blanket licenses for, ASCAP and BMI's license for the university is subject to a lot of different things. But the point is that the blanket license can be, operate in the same way for the streamers, or they can maintain their direct deals if they prefer to deal directly with the record companies for that. The record companies and the music publishers, that is. You'll recall the notice of intention is required letter to state that I'm going to make these records, and so you kind of put yourself on the radar of the owner. The Aeolian Company, it was that piano roll company we talked about that had a monopoly over the music marketplace and precipitated the first compulsory mechanical license in 1909. The statutory rate was set by the government at that time. It's not two. It wasn't initially 2 cents. It was 0.2 cents. So it's gone up. Oh, no, it was 2 cents and it's gone up to 9.1. That's right. And then the Music Modernization Act of 2018 had created the Music Licensing Collective, which is in charge of issuing the blanket licenses, tethering the Circle C owners to the Circle P owners on various recordings, and establishing that database. And then finally, a controlled composition is simply a song that a performer also wrote. So it's like a singer-songwriter situation. They're the performer and the songwriter. So that's how you kind of get in two streams of income in the music business and make it pay a little bit more. Okay, so let me know if you've got any questions. I hope you have enjoyed this presentation, and I look forward to your presentations. I've been enjoying them quite a bit. So yes, have a great day.